I'll return to the placard's assertion that I began with. To exclaim the occasion of your inaugural experience of having legal sex carries a very powerful symbolic message that might do nothing to make us have better orgasms. But symbols of emancipation are not mere bourgeois vanity. They have real affective consequences.
I am the Advocate General for a state. I don't represent the state when I say this, because the state would have possibly a very, very different point of view than what I'm going to say. And that's because I think the contours of the state, it's a largely conservative state. It has would possibly have a very different view than what I would like to sort of place as my personal views in this. Secondly, I don't represent anyone. I'm just saying it from what my personal perception of the topic and the issues which are raised in this discussion. So, how do I perceive it? Now, there are broadly two ways I perceive the issue. The first is, and I perceive it in a very commonsensical way, and I don't perceive it in a very academic way or in a great sort of as an exposition of the rights discourse, which we are all used to in law schools. I perceive it as an issue which is beyond the rights paradigm. I perceive the fact that I perceive it in the broad way that sort of Indian society has always perceived sexual preferences. That what you do is your life, what you do is up to you, and just like it should not be criminalized. But on the other hand, politicization of the issue is also something which is not something which is to be looked forward to. On one hand, there is no doubt about it that broadly, what a person prefers to do is governed by his privacy. That's one aspect of the matter, and that's how it should be. But to then sort of make the personal political is something which is difficult to comprehend. I understand also that this is coupled with the entire rights discourse which has happened in the West. Like everything has to be exemplified by one sort of right. So you have a sexual right as well. You have your rights coming out of your existence as a person, the multiple ways and multiple rights which arise from your existence as a person. But my perception is that we live in a realist society. We live in a society which is very different. We live in a society which does not exist only in academia. We exist in a real world. And there are people with very, very different views from what happens in academia. So by making an issue political, moment you make it an issue political and define a group as a minority, you therefore create automatically, by flagging that issue, a majority. And then by creating an identity of a majority and a minority, you create a discourse which may be good for academia, maybe good for activists, but actually on the people on the ground, I don't know how much it works. Second question, should there be criminalization of sexual preferences? I think just as politicization of preferences is incorrect, I don't think there should be criminalization. Speaking for myself. But most importantly, and this is something which I would like to flag, should it be the legislature or the executive's prerogative to change the law? If anyone sees section 377, which we are all used to, we've gone through it in great detail, everyone I'm sure knows it inside out. I think in this case, it is incumbent upon the judiciary. The judiciary had this entire matter confronting it. And if you look at the section, of course, there is a case for that a section is too widely worded. What is against the order of nature? And, that needed to be defined. But the judiciary refused to bite the bullet. The judiciary should have defined it. It was very easy for the judiciary to have solved it. It need not even have sort of held the provision to be unconstitutional. All it needed to do was to define what is the order of nature. And, it is a wide enough clause. It gives a very wide prerogative to the judiciary, and that's the reason. If you look at if you look at the words of the IPC, then IPC is usually, as all of us know who practice criminal law, that IPC is extremely specific in most issues. And the reason why possibly the IPC framed the provision in this manner is because it wanted a flexibility to the judiciary to decide on this issue. The fact that the judiciary refused to bite the bullet is something which judiciary should rethink. And to contextualize changes, what has happened in society, and reflect it in the law is the judiciary's prerogative.
As a student of constitutional law, my criticism was not based on my or on any kind of opposition to gay rights. It was based on the High Court's position vis-a-vis the Supreme Court interpretation of the Constitution. And that's why I simply pointed out that the way the High Court has interpreted Articles 14, 15, and 21, they have not yet been interpreted by the Supreme Court. And therefore, there is a contradiction between the decision of the High Court and the decisions of the Supreme Court. And unless the Supreme Court, and Supreme Court too, because there are 7 judges bench already, which are establishing the law. So the Supreme Court too has to overrule it by perhaps a larger bench, though now Supreme Court, even by the Constitution bench of 5 judges, are actually overruling some of the larger bench decisions, perhaps in view of maybe too much work with the court and too few judges in the Supreme Court. They have decided to follow that practice. So maybe it can be overruled even 5-judge bench. But when the matter came to the Supreme Court also assigned it only to 2 judges bench. And in the Supreme Court also, I found some favor in the sense that the Supreme Court overruled Naz Foundation. And primarily the overruling was on constitutional grounds, that there is no violation of either Article 14 or Article 21 of the Constitution so far as the law is concerned. Now, it is again, when Supreme Court decision came, of course I felt that perhaps this could be expected, and therefore the court has decided this way, and perhaps the 2-judge bench did not have any other choice in deciding that matter. Now, what is the way out means in this situation? One of the way out which I have suggested, and even the High Court could have done at its level without coming in conflict with any decision of the Supreme Court, that in view of what is happening all around the world with respect to the freedom of the individual or the right to privacy, whatever, though of course right to privacy is under challenge, whether there is a fundamental right to privacy under the Constitution. But assuming that there is a right to privacy, that people have that kind of right, the court could have taken a slight different route which was available to it, and could have simply said that in view of the scientific and other developments which have taken place in most of the countries of the world, there is nothing unnatural in same-sex people having this kind of relationship, so long as they are adults and they are consenting. And therefore, without invalidating section 377 of the code, the court could have actually given us a guidance that the law would not be applicable, because it is not applicable to certain groups of people. And this is what Supreme Court also seems to have said in Kaushal case indirectly, when they say there have been nearly 200 and odd cases before us, but all of them are non-consensual sex cases in these same-sex people, and therefore not a single case has been brought to us in which consenting adults have been prosecuted and punished by any court. So it is in that view the court overcame that issue and decided it the way it decided.
Really apologize. I would have liked to have been part of a more extensive discussion, but I'll have to say my piece and leave in about 10 minutes. And I really, really apologize for that. I know that when Salman asked me, I had a choice between saying it's impossible or saying I'll do my very best to squeeze it in, and I thought the latter might be better than not showing up at all, which was the only other viable option. But I do want to say how pleased I am that under the auspices of these very distinguished individuals are having such a serious discussion on such an important subject. And I think I'll pick up from the very conclusion of Professor Singh that he hopes the legislature will address the question of 377, because that's precisely where I tried to come in. You know that when the Delhi High Court judgment came in 2009, our government quite consciously decided to just let it be. In other words, even though there was some sentiment, some retrograde sentiment in the ruling coalition, a conscious decision was made. There would be no attempt made to reverse the effects of that decision, and therefore, essentially, Section 377 was invalidated by the Delhi High Court and remained invalid until December of 2013, when, as we know, the Supreme Court reinstated it. Now, we have often been asked, people of Salman's and my persuasion, as it were, in politics, if we feel it's so wrong, why didn't we do something about it? Well, literally, it was not possible. There was only one 2-week session of Parliament between the Supreme Court judgment of December 2013 and the imposition of the Code of Conduct before the elections of 2014. And the only thing that was done in those 2 weeks was to pass the temporary budget, the voter account as it's called. So it would have been impossible for us to introduce any fresh legislation at that time. And needless to say, at that point, in any case, it would have taken some time to create the legislation, put it forward, and so on. So we had to wait till after the elections of 2014. We did not win, as you know very well, and the government that came to power, we gave them some time. They seemed to show no inclination whatsoever, despite some public statements, both by one of the leading lights of that government, Mr. Jaitley, the finance minister, and by the first law minister, Sadananda Gowda, the second law minister, who was in office for much of 2015, saying that he was not in favor of 377 and the law should go. But when it came to actually presenting anything to Parliament, they both did not do so. So I decided to use the mechanism of a private member's bill. First of all, to draw attention to the issue, and secondly, to actually shame them into taking it up. I got some cooperation from a number of NGOs working in this field. My own staff did the writing. I had a lawyer working with me in my office, and the private members' bill was sought to be introduced in December of 2015. Well, what was totally astonishing to me was that not only was this not a case of simple inattention by the government having, as we had wrongly thought, other priorities, therefore we can push this priority into their hands by bringing this bill. It turned out that the attention they paid had been entirely negative, because despite these voices having been raised in the government, when I attempted to introduce the bill, to my astonishment, the BJP had mustered 74 members on a Friday afternoon, which I can tell you is extremely unusual, to shout down the introduction of the bill in a voice vote. I somewhat forlornly asked for a recorded vote and lost it 74 to 27 or something like that, and that was that. At this point, I realized that the opposition was a little more serious. Mr. Sadanand Gowda, whom I had spoken to even just before the introduction of the private members bill, voted with those who would shut it down. Because when it comes to votes in the Lok Sabha, the crowd mentality immediately takes over. It's partly a result of the whip system, though on this one I'm told there was no whip. The two BJP MPs I had spoken to, one was him and the other was a young man whom I probably should not name in the interest of his own self-preservation. He told me very proudly afterwards, see, I kept my word, I abstained. And I said, but your word was not to abstain, it was to support this bill. But at least he abstained. There was no whip obliging him to vote. But some of the others, including in this case the Law Minister, suddenly perhaps taken aback by the passion with which elements of his party had decided to oppose it, decided to go along. I tried a second time, but this time after speaking to a number of my party members and other allies, I had the support of my party leadership. Both Mr. Sonia Gandhi and Rahul Gandhi in the internal Congress party meeting in Parliament said that they support this and they urge people to support me. But inevitably, I mean, that's one of the curses of private members' bills. They always come up on a Friday afternoon. Many have other fish to fry on a Friday afternoon. Many have flights to catch to their constituencies. The attendance was even worse than on the first occasion. And though the BJP also mustered fewer people, they again insisted on the vote. This time it was not I who insisted on the vote, and they won it by something like 59 to 23. At this point, I remembered Einstein's definition of insanity as being trying the same thing over and over again in the expectation of a different result. It was clear to me there wasn't going to be a different result. Now, what was frustrating about this was, of course, part of the objective of the opponents of this attempt of mine was to prevent arguments from being aired. Because if you could shut it down before the introduction, there'd never be a substantive debate. I had at one level concluded we were to lose this debate, but at least I thought by placing the issues before the House, and thereby, of course, before the nation on Lok Sabha TV and so on, that we'd be able to get a substantive awareness of the issues. I had throughout tried to position the issue, which, you know, in the usual Indian sort of sniggering, homophobic tradition was being sort of joked about as if it was something to do only with sex. I had tried to position the issue as being not about sex, but about freedom, about the constitutional provisions of Articles 14, 15, and 21 on dignity, privacy, and equality, all of which, in principle, have been violated by the persistence of 377, as indeed the Delhi High Court found. And by situating it as one of an issue of constitutional freedom, I wanted to take it beyond advocates of LGBT rights to a national issue that every right-thinking Indian ought to be concerned about. Because the moment an issue becomes owned by a particular section of society, the great danger is always that it becomes an issue only of that section and everybody else is indifferent or hostile. So I wanted to make sure that the debate explained the issue broadly. A second point that I made in the op-eds that I wrote about it at the time was how ironic it was that the BJP, the party of Hindutva, a faith which had had absolutely no recorded instance of the proscription or prohibition or persecution of sexual deviancy, a religion whose mythology and so on had talked about Shikhandin, whose sacred texts use the word Napunsak in talking about certain kinds of people, which had constantly accepted the various manifestations of human condition, whose erotic sculptures in Khajuraho actually depict, amongst other kinds of behavior, also homoerotic behavior. All of these things in the Hindu faith And the party of Hindutva was opposing all of this in the defense of a Victorian piece of legislation drafted in 1837 by Macaulay, adopted in 1861, which the British themselves had long since abandoned in England. I mean, the savage irony of this was something that I also wanted to point out. That essentially ancient Indian tradition, Hindu tradition, was being betrayed in defense of Victorian morality. But both these arguments, that this is about constitutional freedom and this is about really violating existing Indian standards of our culture and civilization, both of these could never be placed before the House because, in fact, opposing the introduction of the bill, which, by the way, turns out to be unprecedented. It has never happened before in the Lok Sabha, that a private member's bill has not been introduced. But that was a deliberate attempt by the opponents of this to stifle debate. Now, where do we stand? I part company with Professor Singh on this because I have no hope for our legislature. Having seen the vehemence, the passion, the bigotry, the homophobia expressed, including some very nasty personal remarks that were flung at me for having introduced a bill about sex, etc., I believe there is simply too much prejudice in this House and perhaps too much opportunistic perception of political disadvantage in supporting such a bill, for such a bill to ever get in the foreseeable future a legislative majority. That is that even people of my own party, I had one mortifying experience of seeing 5 friends of mine get up and walk out just before my bill was to be introduced because they didn't have a heart to oppose me, but they didn't want to be recorded as voting in favor of homosexuality. It's as simple as that. And I know that there are issues. I mean, I come from a state which is over 20% Christian, 23%, and the church is completely opposed to the lifting of the prohibition on Section 377, and bishops and cardinals will make it very clear to you that they are. So this is a problem, and I've had some painful conversations with my own cardinal, and I'm not a Christian, but I'm the cardinal from my constituency. It's not an easy issue politically, but part of the thing about being a quote-unquote leader is you should be prepared to lead beyond the prejudices of your followers, and that, unfortunately, many politicians are not. The only way, in other words, Professor Singh, that your formula will work is if some very enlightened BJP leader persuades his own party during the majority of the BJP in this Lok Sabha that this is the right thing to do. Whatever reason he may give, he can give cynical reasons about international acceptability. I don't really care what reasons it may be. But if he were to give such a reason and have a whip issued obliging people to vote for it, then it will pass. But I see absolutely no prospect of any such initiative being on the horizon. And I'm fairly confident that even if such a proposal were made in cabinet, that it would be opposed so bitterly by certain elements that it would not actually come to the House. And this is why I have publicly placed my faith in the Supreme Court. The truth is the Supreme Court has, in a series of judgments in the 90s, genuinely expanded the scope of our freedoms when it comes to women and women's rights. And there is absolutely no reason why the court might not be inclined to do the same in respect of sexual minorities. The truth is that the judgment of 2013 has often been willfully misread. Yes, it may have been passed by fairly conservative or orthodox-leaning judges, whatever it may be. I don't know the individuals. But the reasoning on the basis of which the Delhi High Court judgment was invalidated was actually a somewhat precious argument about judicial overreach. What the judgment says essentially is such issues are the prerogative of the legislature and not of the judiciary. So why is the High Court taking upon itself the responsibility of doing the legislature's job? That was the nub of the finding in the 2000. Now, obviously, the Nas Foundation appeal, the decision to conduct a review, means that this question can be addressed. And we've had a rather activist judiciary, which has in many, many areas overreached itself, as I'm sure Salman, as a former law minister, has had occasion to feel. And certainly, one could argue that, in fact, that judgment is an aberration in terms of seemingly restricting the judiciary's authority to pronounce itself on any matter in our country. We all know that the judiciary has done everything from insisting on compressed natural gas in trucks and lorries in Delhi, which by no stretch of any country's imagination would have been a judicial matter well, it is in India, all the way through to many of the judgments in recent days which have had the government sort of turning purple with apoplexy about the judges' interference in matters that are, they would argue, the prerogative of the executive. So why on this particular issue the judiciary should suddenly find virtue in judicial restraint is, to my mind, a highly debatable matter. Both the judges have retired. The 5-judge review bench can presumably take a broader and frankly more up-to-date view. The only thing that worries me about this hope and prayer that it will move in this way is that for some obscure reason, since the decision was made in March that they would conduct a review, they still haven't listed it. And this is now, isn't this unusual that after you decide to review something that you take 6 months and still haven't listed it for discussion for review?
Something that's being reviewed now by 7 judges that goes back to 1990. So it's really, you get in the queue, and it requires a very special effort and inclination of the court to take it out of turn.
Oh, I see. So the term could actually make us wait another 20 years for justice.
By which time attitudes would have changed adequately for you to get the right decision.
For the legislature. We may have a different majority in the Lok Sabha, who knows. I really apologize for abandoning you all. This is an important subject, but I did want to say my piece, and forgive me, I really have to.
Logic with which our response to 377 or broadly the question of homosexuality works, I think we'll be mistaken to actually locate progressiveness and aggressiveness on a rural-urban divide. And one case that comes to mind is the matrimonial advertisement which was published in Midday. I don't know how many of you remember it, by Harish Iyer, who's a well-known gay rights activist from Bombay. His mother put out this matrimonial ad, which was the first of its kind in India, and she was seeking responses from a man to marry her son. But the matrimonial ad, amongst all the progressive things it said, also added in parentheses, Iyer's preferred. So you have a certain kind of sexual progressiveness accompanied by a certain kind of caste regressiveness. And so those are kind of the complicated intersections we need to be attentive to when we generally place the question of sexual rights or sexual preferences on this kind of urban-rural divide, which is a slightly problematic fault line, I think. Over to you, Mr. Khurshid.
Well, thank you. We've had, I think we've had an interesting range of comments on this, and I'm sure that young people have a lot of questions to ask, so I will be very brief. I do believe that although we've seen this in the context really of a specific condition, which people suffer, certain people suffer because of the nature of our law. I think there is a broader principle involved, and the High Court had remarkably identified that principle about individual autonomy, which sums up many of our outstanding decisions about human dignity, about the right to conduct your life in a manner that you please. And I think it's this is in contradistinction with what I believe is an over-legislated system. Our lives are over-legislated. There is almost a sense of state paternalism telling you how to behave, what to think, what to do, how to conduct yourself. Now, given that whether it's legitimate or illegitimate, But the fact remains that we are going through times where there is a significant opinion, perhaps transitory, but certainly a significant political opinion that society needs to be ordered in a particular manner because the state knows better than the individual. Now, if that's the trend that we are going to see in our country, and if that's the trend that will remain, then it would be difficult to think of a situation such as NAS being accepted as an exception to that trend. When NAS judgment came from the High Court, it was obviously, for understandable reasons, vigorously objected to by conservative elements belonging to various religious denominations. And for me, the takeaway from NAS, other than the far-reaching opportunity that it recognized for people in terms of real equality, the takeaway from NAS was this phrase for which the judgment relied heavily on Jawaharlal Nehru's perception of what our national life should be, and the word autonomy figures there as to how an individual has to be and the individual's autonomy has to be respected. So this whole idea of autonomy then tells us, what are you going to do if you highlight autonomy, support autonomy, wish to preserve and fortify autonomy? What are you going to do when another trend says we must standardize personal laws in this country? So there is now a significant effort to standardize personal laws under what's called the Uniform Civil Code syntax. But a uniform code and diversity are two different things. How are we going to combine diversity with uniformity? This has been a perennial question for all plural societies, and certainly for India. And right now, there seems to be an eye for uniformity as against diversity. And diversity is sometimes seen as being a threat to the fabric of society. And there, the law of sedition, as you know, and the Supreme Court is dealing with it. The law of sedition now has become a serious test case for what kind of diversity are we willing to accommodate, or we are obliged to respect, and to what extent must we continue to work and labor for greater uniformity in order to protect society. So I think that this question is significant as it is for individuals and their personal aspirations in how they live their own personal lives. I think also signifies and flags a larger important question about diversity and uniformity in our country.
We would now